This is Professor Taylor's video lecture on the materials pertaining to care and candor in pleading, in particular Rule 11 of the Federal Rules of Civil Procedure. This is just going to be sort of a brief overview of the quote-unquote substantive rule of law that Rule 11 imposes, and then we'll spend our time in class talking about how this rule applied in the context of the cases in the text. So I want to begin by sort of breaking down the rule into a four-part structure. And as I do this, I want you to make sure you have your rule book or a copy of Rule 11 in any event in front of you so that you can track through the rule as we talk about each part of it. So if you need to, pause this video right now and make sure you've got the rule. So like I said, we're going to break the rule down into four components in terms of its structure. One is the scope of the applicability of the rule. To what kinds of papers and in what circumstances does it apply? Two is the obligations that it imposes. What does Rule 11 require a lawyer or a party to do? Three is the procedural mechanism by which the rule is applied. How is the rule invoked, by whom, and in what way? And then four is the consequences for a violation. What happens if the rule is violated? So we're going to talk through each of those four in turn. First, as to the scope of the applicability of the rule. Let's begin here with the very beginning of the rule, Rule 11a. It says that every pleading, written motion, and other paper must be signed by at least one attorney of record in the attorney's name. So the rule applies at the outset to pleadings, written motions, and other papers. So written things that are filed or presented by to the court. They must be signed by the attorney. And moving on to 11b, what it says, the rule refers to the circumstances in which the rule applies with respect to those pleadings. It pertains to signing, filing, submitting, or later advocating anything in a pleading, written motion, or other paper. So note that even though Rule 11a begins with reference only to written matters, there is inclusion under that part of 11b of this concept of later advocating, which may include oral advocacy in addition to writing. Note also what this doesn't include. It doesn't include any sort of affirmative obligation to correct. So it applies to anything that is actually filed, signed, filed, submitted, or later advocated, but is silent as to any sort of affirmative obligation to correct past signings, filings, submissions, or advocations, so to speak. Also important to note that the rule is expressed in its inapplicability to discovery, and that you can find in Rule 11d at the very end of the rule. This rule does not apply to disclosures and discovery requests, responses, objections, and motions under Rules 26 through 37. And we'll talk about why that is when we get to discovery, and you'll see then that the discovery rules include their own sort of policing mechanism of this sort. As to what the obligations are that the rule imposes, there are several. Rule 11b is the core provision here, and as the text explains, and as you can see in the rule requires inquiry reasonable under the circumstances. And we'll be talking in class about what that means, particularly in the context of the Hayes versus Sony Corp of America case. But in the meantime, I want us to understand, just as a basic proposition, what it is that a lawyer has to inquire into. Into what must the lawyer inquire? Well, these are the other subparts under Rule 11b, and they can be grouped into two basic categories. One is the facts. So a lawyer has to conduct an inquiry reasonable under the circumstances into the facts underlying a pleading, written motion, or other paper that he or she signs. And you can see this reflected in Rule 11b-3, which requires that the factual contentions have evidentiary support, or if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. And we referred to this concept before, that you don't necessarily have to have all of the evidence gathered at the time the facts are presented, for instance, in a complaint. But as this rule indicates, if that evidentiary support is not currently available, there must be, in order to be consistent with your Rule 11 obligations as the lawyer, you have to either have that evidentiary support or believe that it's likely that you'll have it after a reasonable opportunity for further investigation or discovery. 11b4 also reflects the obligation to investigate the facts, but is presented more from the defendant's perspective, that denials of factual contentions must be warranted on the evidence or is specifically so identified or reasonably based on a belief or lack of information. So that's sort of the flip side of the factual investigation imposed upon the defending party. And then secondly, the rule imposes an obligation to conduct an inquiry reasonable in the circumstances into the law. And let's look at Rule 11b2 in particular on this point. It says that the claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law or establishing new law. And we see this provision at work in both of the principal cases that you've been assigned to read, Hayes versus Sony Corp of America and Hunter versus Earth Grains Bakery. And I want you to note as you read those cases the differences in the way that that rule applied in those two cases and how the court handled the Rule 11 issue under Rule 11b in each of those cases. And then in terms of other substantive obligations, the pleadings must also not be presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. And you can see that in Rule 11b1. So the lawyer has to inquire reasonably into the facts and the law underlying the paper that is presented to the court and must not be presenting it for any improper purpose. And I think those terms are relatively self-explanatory in this context. We're actually skipping over the case in the text that delves in more detail into this on the premise that the case is somewhat complicated and the terms are somewhat self-explanatory. And should you ever need to look into this, obviously you would just need to do the legal research on it. In terms of the procedural mechanism by which Rule 11 is invoked, there are a few very important points to note. First is who can invoke Rule 11. A lawyer or an opposing party can invoke it, and I say put opposing in parentheses here because, of course, the party invoking the rule would be invoking it against the other party who is alleged to be violating the rule. So the party to whom the provision applies is not the party who's invoking it, it's the other party. So that party can invoke the rule by motion under Rule 11c2, and that rule provides that the motion must be made separately from any other motion. The policy behind that would be simply to make clear that this is a Rule 11 motion and you better take it seriously, and must describe the specific conduct that's alleged to violate the rule. So a lawyer or party who's alleged to be in violation of Rule 11 is should be put on specific notice of what they've allegedly done in violation of it. But notably, it's not only a party or attorney who alleges the other party is violating Rule 11 that can invoke it. In addition to that, the court itself can invoke Rule 11, and Rule 11c3 contemplates this by requiring the court to issue what we call a show cause order. So this would be an order that just comes from the court and says, this court orders that party A in this lawsuit show cause why Rule 11 sanctions should not be granted for XYZ paper because of XYZ reason, and explain what the alleged violation is. Also important to note the safe harbor provision here, which is found in Rule 11c2. And this is a unique provision pertaining to Rule 11 motions that doesn't have wide application otherwise. So most motions, you can just file them without any notice to the other party, regardless of what kind of motion it is, as long as the motion is timely under the rules. But under Rule 11c2, a Rule 11 motion cannot be filed unless it has first been served under Rule 5 and 21 days have then passed. So let's look at that part of the rule. It's the second sentence of Rule 11C2. The motion must be served under Rule 5, but it must not be filed or be presented to the court if the challenged paper, claim, defense, contention, or denial is withdrawn or appropriately corrected within 21 days after service or within another time the court sets. So the idea here is that the party who is allegedly in violation of Rule 11 should get the opportunity to correct the problem before the court has to get involved. So say defendant says, plaintiff, I think your claim, your third count in your complaint for breach of contract is a violation of Rule 11 because there's no fact suggesting any contract was ever entered into. That motion should be served on the plaintiff by the defendant, but then the defendant needs to wait 21 days before filing it to give the plaintiff a chance to correct the problem. Okay, next, consequences for violation. What happens if the rule is found to have been violated? Sanctions. And the rule says under 11C4 that sanctions under Rule 11C4 should be limited to what suffices to deter repetition of the conduct or comparable conduct by others similarly situated. And so that's the basic theme to the sanctions. And as to what they can include a non-monetary directive. I've seen such things as ordering a lawyer to write an apology letter or ordering a lawyer to attend CLEs for, extra number of hours over the next year, a penalty paid to the court, or, as my slide had already indicated, payment of the movant's fees and expenses. So the non-movant who is in violation of Rule 11 can be forced to pay the movant's fees and expenses directly resulting from the violation. Not all their fees and expenses, but those resulting from the violation of Rule 11. Note, however, the limit imposed by Rule 11C5A, which is that a court cannot impose a monetary sanction against a represented party for violating Rule 11B2. And that is the provision, if you look back up at 11B2, that requires that the claims, defenses, and other legal contentions be warranted by the law. So if you think about that, it might make some sense to you that a monetary sanction can be imposed on a party if, for instance, they're not being forthcoming with the facts or are misrepresenting the facts in a way that is causing the Rule 11 violation. But knowledge of the law should be the lawyer's province. So that provision applies only to lawyers. Non-lawyers can't be sanctioned for violating Rule 11B2. So that wraps up our sort of breakdown of Rule 11. I just want to leave you with a couple of tips as you read through the cases in this chapter in terms of what to look for. In each of the two cases that I've asked you to read, the Hunter or Hayes versus Sony Corp and Hunter versus Earth Grains Bakery cases, I want you to look for how Rule 11 was allegedly violated, which, and in particular, what it is that the lawyer or party did that is alleged to have violated Rule 11, and which provision of the rule that might violate. Then I want you to look for how Rule 11 was raised procedurally. Was it by a party? Did they follow the proper procedures under the rule? Or was it by the court sua sponte under that show cause order provision? And then, as we usually look for, why the court reached the decision that it did on the Rule 11 issue presented. What was the court's rationale? So that pretty well wraps up this video, and we'll be talking through those cases in class when we turn to Rule 11.